In this lesson, what we're going to do is just take the last of our conversations relating to a general introduction to human rights in the UK by focusing on this idea of human rights as exhibited through and enshrined by the common law. Now, the reason why this is important is because, of course, we're going to be looking at the ways in which the common law has added to and interpreted a number of different provisions within human rights law in the United Kingdom throughout the rest of this series of lessons. But I thought it'd be important to just talk about the influence of the common law on general human rights from a historical perspective before we start to talk about the Human Rights Act in a little bit more detail. So, like I said, the last lesson looks at the history of statutory reform as well as legal instruments. I'm just using that as the kind of general phrase relating to the application of human rights. Now, in this lesson, we're talking about the influence of the common law on the development of human rights principles. And it's important that we talk about the common law in this regard because when we look at various different cases on interpreting the Human Rights Act, the principles and ideas that have been established by the common law are very important in that regard. They're very important in developing and adding to the corpus of human rights language and human rights legal doctrine that we will take for granted when we examine the nature of human rights in the United Kingdom. And so, for those who are uninitiated to the common law simply refers to judge-made law that has developed over many, many, many years, many hundreds of years, beginning in the main period of the sort of Angevin Empire in around the 1200s. So, a very, very long time ago. Now, essentially, we're going to talk about some highlighted examples where the common law has added to principles of human rights without reference to the Human Rights Act. So when we talk about the Human Rights Act in more future lessons, when we talk about provisions like the right to life and the right to family life, and privacy and things like that, we're going to talk about the provisions that are established by the Human Rights Act. But we're going to also talk about the ways in which the common law has taken those provisions and developed them through various case judgments. But these are examples of common law applications of human rights which do not pertain specifically to the Human Rights Act in any great detail. So, essentially, principles related to human rights has been developed throughout the common law, going back as far as the 1700s. Now, back in the 1700s, while Parliament was still sovereign, because Parliament has been essentially sovereign since 1688, there was still this seeming influence of the common law as being a dominant system of legal creation and lawmaking. And so it's important that we note that even though Parliament was still very influential during this period, it is also still the case that the common law had quite a significant amount of influence as well. And we can see some of the ways in which human rights has been influenced, should I say, by the common law when we look at the 1700s and we look at the case of 1772, specifically this case of Somerset and Stuart. Now, what this essentially involved is a very historical, a very dated set of factual circumstances because it involved an escaped slave. So this was a period where we are still seeing the heights of the Atlantic slave trade, and we are seeing the impact of slavery across throughout the British Empire and the sort of colonialism that existed in the Americas. And bear in mind that this is not even before the founding of America. We see the founding of America literally a few years after this case. But ultimately, this was a case which involved an escaped slave who was recaptured. And the legal dispute was around the possibility of sending this slave back to the Americas. And the question of whether or not that was a legal recourse that could have been implemented. Now, more recent cases talks about how we see the application of human rights norms from the common law perspective, but it should be noted that one of the impacts and one of the influences that was at play here in the case of Somerset and Stuart is this question of whether or not the right of the human being who was classified as the slave in this regard should be considered when making the decision as to whether or not they should be sent back to the Americas to live out the rest of their lives as slaves. Now, in terms of a more recent case in the application of slavery, we can look to the case that comes just before the passage of the Human Rights Act, and a few years before the implementation and the entry into force of the Human Rights Act. And this is the Witham case of R and the Lord Chancellor. It was a case which involved the tort of defamation. Now, the question for the court in this case related to the issue about whether or not there was a right to access the courts, the right of access to court systems. And the Court of Appeal had held that the common law recognised that there existed a number of special protections, such as the right of access to the court, and that these special protections were considered to be something of a constitutional right. And so, as a result of which, we see that even before the passage of the Human Rights Act, even before as well or at least even during and living and existing in conjunction with the UK's adherence to the Council of Europe and the European Convention on Human Rights, the Court of Appeal recognised that there were such special protections and rights which existed as constitutional rights that weren't enshrined necessarily by statutory provisions like with the Human Rights Act, but instead they were provided for by the common law. And so that's why this case has quite an interesting amount of influence. Similarly, in 1999, so this is a year after the passing of the Human Rights Act, but actually a year before the entering into force of the Human Rights Act. So the Human Rights Act would be passed in 1998, but it wouldn't enter into force until the year 2000. And this is the XP Sims case of against the Secretary of State for the Home Department. Again, this was a case which involved human rights, specifically a freedom-related right, which is the freedom of expression. A prisoner wanted to do a journalistic interview, but what the prison had done was put a blanket ban on the allowance of interviews in all of their possible characteristics or possible forms. So any interview whatsoever could not be done as per this rule that was implemented by the prison. So this is the question, whether or not the freedom of expression of this prisoner had been infringed by the fact that the prison had put this blanket ban on the allowance of interviews when this prisoner wanted to do a journalistic interview. Was this a violation of their freedom of expression? Now, it was held by the House of Lords that the use of the freedom of expression was not an absolute right in English law, but rather it was a right which could be limited in certain circumstances. So as a result of this, they made the argument that the freedom of expression is not an absolute right as per the common law description within English law. But they also made it very clear as well that the limitation of the freedom of expression in this specific case was towards the intention on the part of a prisoner to challenge their conviction, which was believed to have been a right of such importance that it did not fall into this limitation on the freedom of expression. So the House of Lords made 2 points. They said, well, while it is the case that the freedom of expression is not an absolute right, we're not going to make that recognition clear. But we're also going to make it very clear that the facts of this particular case does not fall into that non-absoluteness, shall we say, of the right of the freedom of expression. In fact, this was a limitation, an illegitimate limitation on the expression of the prisoner, because the prisoner wanted to challenge their conviction. And so it was believed that this was considered to be something of a human right and something that was meriting protection from the court systems.